Hello, and welcome to Emerging Viewpoints. I'm Nick Stadtmiller. Today we're joined by Cem Tecimer to discuss the Turkish opposition's desire to return Turkey to a parliamentary system of government, accusations of political meddling in the judiciary, and what to expect if Erdogan and his allies win re-election at the next election. Cem is a constitutional law scholar and a PhD candidate at Harvard Law School. He holds a law degree from Koç University in Istanbul and is a dual qualified lawyer, having been admitted to the bar in both New York and Istanbul. Cem, welcome.
Hi, Nick. It's great to be here, and I look forward to answering your questions.
So let's kick it off. One of the few things that the opposition parties can agree on is a desire to return to a parliamentary system of government in Turkey. Now, the current system is a presidential system after President Erdogan was able to usher through a referendum of constitutional changes in 2017 that created that presidential system. And presumably, to return to a parliamentary system would require new constitutional amendments. So, Cem, can you talk us through some of the procedures and how long it might take if the opposition are able to win and push through their desire to change the constitution again?
Sure, and that's a very timely question, Nick. Not least because reputable polling firms in Turkey, their results from various sort of pollings have been indicating that the opposition might predictably win the upcoming presidential and parliamentary elections, and of course, they have indicated a joint desire to return to a parliamentary system. But before I answer that question, I think a brief but still relevant tangent, I hope, is in order, and that is the way in which we characterize the current system of government in Turkey as being a presidential system. And we all describe it as such, and by we, I mean the lay public and pundits, but I think we do so somewhat erroneously, but because I think calling Turkey currently a presidential system is a bit of a misnomer from at least a comparative constitutional law and constitutional theory perspective, because in presidential systems, at least in its sort of Western iterations, I'm thinking first and foremost of the United States, you see a rather strict separation between the political branches of government, by which I mean the executive and the legislature, right, the presidency and Congress in the case of the United States. And by that I mean, for example, in the U.S., apart from the fact that the president requires the consent and advice of the Senate from time to time with regard to some senior judicial and bureaucratic appointments, or the fact that the president can veto certain legislation, of course, which Congress can then override. You don't really see, as a matter of black letter law at least, the need for inter-branch cooperation, which is, after all, what presidential systems are all about, right? They're marked by a strict separation, as I said, between political branches of government. However, you don't see that in the case of Turkey, not only because of political party structures and affiliations and high party discipline, but also because, as a matter of black letter Turkish constitutional law, the president, for example, can, at his discretion, dissolve parliament, right? Which would then trigger new presidential elections as well. So there's a disincentive for the president in that sense. But still, as a matter of black letter law, he can do that, and vice versa. The parliament can, with a qualified majority, though, do the same. That is, dissolve parliament and also the presidency. And to top that, presidential and parliamentary elections in Turkey are held on the same day, which is again very atypical. I'm sure this was, deliberate on the drafters of the 2017, on the part of the drafters of the 2017 amendment package, because they wanted to ensure that the same people, so to speak, right, people with same political party affiliations would occupy both the presidency and the parliament. Again, very atypical of presidential system configurations in certain parts of the world. So I would venture to call Turkey's current system a presidentialist system, iterations of which we see in other parts of the world, or as the Financial Times, I believe, referred to it in one instance, a turbo presidency. No, so that caveat aside, to answer your question, you're right that the opposition would need to amend the Turkish constitution, because let's remember a constitutional amendment package was the way in which Turkey was transitioned to the current presidentialist system that it is governed under. So a constitutional amendment would require the passing of a constitutional amendment package by the Turkish parliament. And then you get to various sort of numerical arrangements there because there needs to be a qualified majority, obviously. At least 3/5 of all MPs in the parliament would need to approve a constitutional amendment package. And currently there are 600 MPs. So that comes down to 360 members at least would need to say yes to a constitutional amendment package that would need to amend various articles of the Turkish constitution to take it back to a parliamentary system. But there's a catch. If the majority that approves a constitutional amendment package is between 3/5 and 2/3 of all members of parliament, so that is from 360 members to 399 members. If you have that sort of majority approving the constitutional amendment, then the amendment package becomes the subject of a constitutional referendum. That is the mandate of the Constitution. It's a requirement. There's no working around it. However, if the majority approving the constitutional amendment package is a 2/3 majority or a higher majority, so it's supermajority, numerically speaking, 400 or more MPs out of 600, then you do not need to hold a referendum. But the president, in his or her discretion, may still decide to hold a constitutional referendum on the amendment package. And I wouldn't dismiss this as an outlandish scenario because in the event, for example, that the opposition commands a substantial majority, say in the parliament, but the presidency is still occupied by the AKP, that is by President Erdogan, he would presumably go to all sorts of lengths to make sure that a return to a parliamentary system doesn't happen. And one way of doing so would be to sort of forestall the process or make it more complicated by, among other things, holding a constitutional referendum on the amendment package. And as for timing, the Constitution and the bylaws of the Grand National Assembly, the Turkish Parliament, mandate that constitutional amendments be discussed swiftly and as sort of priority matters urgently. So timing-wise, it wouldn't take really a lot. But this all depends on the opposition, of course, agreeing, ideally in advance, on a constitutional amendment package and not waiting for the elections, right, to come up with and finesse the details of that constitutional amendment package that would help Turkey retransition to a parliamentary system.
So let's say the opposition wins parliaments and the presidency, but they fall short of the 3/5 majority that they would need to push a constitutional amendment to a referendum. Is there any way that the president and a new parliament could agree de facto to operate as a parliamentary democracy, even though de jure it is still in the current presidentialist system, as you call it?
Yeah, that's a great question, and I think that's one of the more likely scenarios, honestly. So that is possible. Although, I mean, your emphasis on de facto, I think, is very important because, as a matter of again black letters of Turkish constitutional law, the president would not be able to sort of legally delegate, say, any of his functions or her functions to the parliament. That would, violate the non-delegation doctrine, so to speak. But as a de facto matter, the president could, in his or her discretion, decide not to exercise some of the extensive powers granted to his or her office by the Constitution, or at least exercise those powers in line with the parliamentary majority, which would more or less, as you've said, resemble a de facto parliamentary system. The question, of course, is once elected to that office, who would guarantee that the new president, even if from the opposition ranks, won't give in to the temptation of exercising that vast array arsenal of powers.
I'd like to shift topics a little bit and one of the most frequent criticisms of Turkey by Western observers, both Western governments and Western businesses, is a fear of the loss of judicial independence. And there are lots of examples that these observers point to, but two of the most prominent, perhaps, are Osman Kavala, the philanthropist and businessman who's been fighting a long running legal battle over his alleged involvement in the 2016 coup attempt and the 2013 Gezi Park protests. And then more recently, Canan Kaftancıoğlu, who is the leader of the CHP, the main opposition party's Istanbul branch, was sentenced to 5 years in prison, although it's not clear if she would serve all of that, but also potentially a ban on her participation in politics. So, can you give us your perspective on the extent of political meddling in the judiciary and how long that's been going on, and what some of the key hallmarks of that alleged involvement are?
Sure. Yeah, Mr. Kavala, as you pointed out, is a prominent human rights activist who, for whatever reason, seems to be getting the brunt of the president's wrath over especially the Gezi Park protests for his alleged involvement in organizing those protests. Also, among the Gezi trial victims, as I call them, because they're victims of a politically captured judiciary, now that you mentioned it, is Mr. Hakan Altanay, by the way, sentenced to 18 years in prison, who's an educator, a liberal in every sense of the word, a one-time senior fellow at Brookings, who also was at one point during my undergrad studies my professor. He taught global civics, so a special shout out to him. I'm confident that Mr. Kavala, Mr. Altanay, and the other victims, as I've been calling them, will regain their freedom once this government is ousted at the ballot box, and hopefully even before that. And as for the Canan Kaftancıoğlu case that you mentioned, again, obviously politically motivated, as evidenced by the fact that the prosecutors decided to prosecute her over tweets that she had tweeted years and years ago. Her case, interestingly, and I think unintentionally on the government's part, seems to have galvanized the opposition. The CHP, the largest opposition party, recently held a rally in Istanbul, and it secured, robust participation from the CHP, but also other factions of the opposition. And it was in part to sort of protest this politically motivated decision. Now, as to your question about judicial independence, I have sort of two thoughts. The first one is that judicial independence comes in various kinds and degrees, so to speak. So in that sense, I think saying, for example, that Turkey does not have judicial independence is sort of a lazy statement, because judges are confronted with. To be clear, I don't take that to be the premise of your question at all, but I do know that is sort of a sentiment that has been floating around. But judges are confronted with thousands of cases, and a majority of them aren't really, politically speaking, high stakes, or they're not even political at all. I'm thinking about corporate disputes, sort of mundane family law related matters, etc. So in these cases, the Turkish judiciary, and these are, again, a majority of cases that judges are called upon to adjudicate. And in these cases, the Turkish judiciary, I think, can be assumed to act without political interference, if only, because political interference is not warranted or required in these sorts of cases. So that's my first sort of observation. The second observation is that a minority of cases are politically salient, some very salient, like the Gezi Park protests cases and the Canan Kaftancıoğlu case that you mentioned. And they are definitely decided in a way that pleases the government. I don't know if we'll ever find a smoking gun kind of evidence, of the kind of political interference involved in politically salient or high stakes cases like these. A kind of direct communication, written or oral, from the presidential palace, say, to judges, ordering them to decide in a particular way. I don't think we're going to find that. But I don't think we need a smoking gun kind of evidence either, right, to understand the extent of political interference. Looking at context, I think, matters. And following the failed coup attempt in 2016, around 4,000 judges and prosecutors were dismissed from their positions. And these, according to figures quoted by the New York Times and the Financial Times, etc. So those judgeships and prosecutorial positions were, of course, filled by newcomers who were mostly and who are mostly regime sympathizers. And actually, Ahmet Shuk, an investigative journalist and an MP, has already compiled a tentative list of now judges, one-time AKP operatives who now, are either judges or prosecutors working within the ranks of the Turkish judiciary. It's a tentative list, but it goes to show that we know, and the opposition certainly knows, of the affiliations of some of these members of the judiciary and the affiliations that they've had in the past and their connections to the AKP. But of course, not all judges have had organic ties to the AKP. A majority of them haven't. But even those judges, I think, would fear, under the current atmosphere, to decide against the government, right, in a politically salient case, because they know they could be retaliated against by being demoted or relocated to another province or city in Turkey, which would mean a huge disruption to a judge's life if they've established their livelihood in a certain part of the country, if they're married, if they have kids. It's a huge disincentive to be relocated, and the government does have the political power to pressure the right sort of constitutional organs and bodies within the judiciary to make that happen. And whataboutists will say that the Turkish judiciary was never fully independent. That's right, but it's an irrelevant distraction, really, to what's going on right now. That the Turkish judiciary was never fully independent in the past is no reason that it shouldn't be right now, right here and right now, right? I hope that answers your question. Those were some general observations.
Yes, and you mentioned that Ahmet Shuk has compiled a list of judges that he and other opposition figures believe to be politically connected and appointed into the judiciary. And I know, Jem, this is something that you've written about, is what could be done about this problem if the opposition are able to win the next election. And it seems to me that just purging all of those judges outright would open the opposition, potentially the future government, to claims that they themselves are politically interfering in the judiciary by purging certain members that they feel are connected to the AKP. So is there a transparent and legal way to ensure that certain politically tainted judges can be sidelined and further the cause of judicial independence?
Yeah, that's a good question, not least because it's forward-looking, and I like forward-looking questions. And you're right, I've been thinking about this one for some time. And openly dismissing judges would, of course, not only repeat an AKP tactic, but also, I think, further harm Turkey's domestic and international reputation, which I'm sure the opposition, if and when they become the new government, will deeply care about. But that being said, I'm sure clever lawyers can come up with ways to sort of sideline AKP operatives in the judiciary, even perhaps by downright dismissing them from their positions. But I can't think of a way to outright oust these operatives, these AKP operatives within the judiciary, without causing a huge legal battle with domestic and international reputational consequences, as I said. But perhaps unseating these AKP operatives in the judiciary is not necessary. It's perhaps not the point. I have sort of two things in mind when I say this. First, these operatives can be sidelined instead of being ousted, right, by being reassigned cases or by being demoted or relocated, right? So assign these AKP operatives the mundane cases, the boring cases, demote them to courts with nominal powers or courts that adjudicate the most boring cases. Again, family law related matters come to mind. Not that I have anything against family law lawyers, but certainly those cases tend to be less politically salient. So reassigning these judges, demoting them, is, I think, one way, one sort of workaround. which doesn't require, which doesn't come with the reputational cost that dismissing them would. But of course, this would require, that is, demoting or changing their these judges' caseloads would require controlling the Judges and Prosecutors Council, which is a constitutional organ responsible for the administrative governance of judges and prosecutors, including their demotions, promotions, relocation decisions, etc. So if that can be done, then I think these sort of tactics to sideline AKP operatives in the judiciary would be one way to go about it. And the second point I have is it's strangely encouraging, but in the long term, I think a sad fact, and it's that maybe the government, the opposition, that is, if and when they become the government, perhaps they don't need to do much because most of the AKP sympathizers in the judiciary, I think, are not staunch supporters of the AKP. They're mostly middle-class Turkish citizens, who've used their AKP affiliation to their economic and social benefit. Now, this is encouraging, perhaps in a perverse way, in that they're not committed to advancing AKP's causes, right, as a doctrinaire would. So, to put it differently, and to use a U.S.-based analogy, for example, it's not as if a majority of federal courts have been captured by Federalist Society-endorsed originalists. That's not the case in Turkey, right? In other words, the lack of militant commitment to the AKP on the part of most of these judges means that once the AKP is no longer the governing party, many, if not most, of these judges will take their cues from the new atmosphere Turkey will find itself in. In the long run, as I said, this is not great from an institutional perspective because it basically means that the judiciary will just change its allegiance as opposed to not declaring allegiance to any sort of political faction. But it will mean in the short term, at least, that AKP allegiance specifically will unofficially become an out, right? That is an unpopular thing for ambitious judges whose main incentives are to remain in their posts and to keep their jobs and to secure promotions moving forward. Now, having said all of that, some of the worst judges, as I call them, can and indeed should be sanctioned. Take, for example, some criminal court judges in Istanbul who some years ago refused to implement and openly defied the decisions of the Turkish Constitutional Court, which hierarchically is, all other courts are inferior to the Turkish Constitutional Court. I can easily make a case that those judges who refused the Constitutional Court's orders should be prosecuted for attempting to violate Turkey's constitutional order, to overthrow the constitutional order, which is a crime regulated in the Turkish Penal Code, and it's subject to life imprisonment potentially. Now, I could get into the technicalities of how that would be possible, but suffice it to say that for the most militant of the AKP operatives in the judiciary, again, a very slim minority, I think heavier sanctions, administrative and even criminal, are possible and fitting. And finally, I don't think Turkish litigants are making proper and frequent use of the institution of judicial recusal when a judge decides to recuse himself or herself from a case. That is, not seeing that, supervising that case at all. To be sure, some Turkish litigants do. For instance, one judge on the criminal court that considered the Gezi protest case and convicted Mr. Kavala, Mr. Altanay, and many others to various imprisonment terms was an AKP member and a candidate for parliament at one point. So the defendant's attorneys in that case actually did ask that judge to recuse himself, but to no avail. But I think that was the exception, and I still think, in general, Turkish litigants can make more aggressive recusal demands in politically salient cases. Not that these requests would guarantee any sort of concrete outcome in those individual cases, but I think even the very act of asking for a recusal serves a purpose, right? It signals to the bench, most immediately, it signals to the bench that their political past is and will be scrutinized to see if there are any political taints, so to speak. and it might incentivize, from a sort of a more institutionalist perspective, other judges or future judges, wannabe judges, to have second thoughts before considering any type of political engagement. So another way of um, ousting AKP operatives in the judiciary, not from the institution of the judiciary more generally, but from specific politically salient cases, would be to make more rigorous and effective use of the judicial recusal mechanism.
So, Jim, you've mentioned a desire to see Mr. Kavala and several others that you and many others believe are imprisoned or face charges for politically motivated purposes, for those people to be freed. Now, if the current opposition win the next election and form the new government, what could that new government do about those cases? Because obviously, those court cases and those prison sentences don't just disappear on the whim of an election. So, what actually could be done by the new government?
Correct. Yeah, a new government technically cannot do much, speaking from a legal standpoint. But I'm almost positive that Mr. Kavala will be set free, and his friends, of course. And the case against Ms. Kaftanjoğlu will be reversed if and when the opposition forces win the upcoming elections. This is partly because, as I've explained before, the judiciary will be more inclined after an AKP defeat to reverse its decisions handed down under that regime. From a legal technical standpoint, though, there are a few judicial avenues for both of these cases that you mentioned. Mr. Kavala's case was decided by a first instance criminal court. Now, that case will be appealed to the intermediate appellate court and then potentially to the Court of Cassation, or rather to the relevant criminal chamber at the Court of Cassation, which is sort of the highest appellate court in Turkey. And from there, if need be, to the Turkish Constitutional Court, which isn't technically an appellate court, but it is sort of a venue for parties who are seeking redress from Court of Cassation judgments. And from thereafter, from the Constitutional Court potentially to the European Court of Human Rights, which has already ruled against Turkey for detaining Mr. Kavala based on what the court considered to be politically motivated purposes. Now, the hope is that Mr. Kavala and his friends won't need to jump through all these hoops because it's exhaustive. It's a whole bureaucratic sort of procedure with different tiers. But the intermediate appellate court can reverse these convictions, right? The court sitting immediately above the first instance criminal court that handed down the punishments. Now, the intermediate appellate court would have every incentive, I think, to set Mr. Kavala and his friends free because Turkey is currently the subject of an ongoing infringement proceeding at the Council of Europe level for allegedly refusing to implement the European Court of Human Rights decision that directed Turkey to release Mr. Kavala, which is to say Turkey would also internationally benefit from releasing Mr. Kavala and his friends. Now, to be completely clear, these decisions in an ideal world, should be made by applying the law, which in and of itself dictates that Mr. Kavala and his friends should be immediately released, but that their release would halt the ongoing proceedings against Turkey at the Council of Europe level is just an added incentive, I think, for an appellate court bench to acquit Mr. Kavala and his friends. And there are similar procedures in place in Ms. Kaftanjoğlu's case. Her case was at the Court of Cassation level. So there are some sort of appeal-like mechanisms at the Court of Cassation level that would enable the court to sort of reassess the case and potentially sort of reverse Ms. Kaftanjoğlu's convictions. But that failing, the Constitutional Court, and that failing, the European Court of Human Rights are still available legal venues for her.
So up until now, we've talked about what if the opposition are able to win the next election. Let's take the other side of that possibility, which is that Mr. Erdogan and his allies are able to hold the presidency and the parliament in Turkey after the next election. Are there any sort of constitutional, legal, or institutional changes you think that Erdogan and the AKP and MHP may pursue after the election if they do win?
Right. The premise of the question is very unpalatable, difficult to swallow, I must say. But it's certainly a question that the Turkish opposition should ponder. Um, and should the People's Alliance win, I would expect a few things. Of first, a further crackdown on what remains of Turkey's free media platforms and institutions. Right. The People's Alliance is already working on an Orwellian social media law aimed at further suppressing anti-government sentiment on these platforms, Twitter, Facebook, etc. So I would expect such efforts to intensify if they remain in power after the next elections. And second, I would expect further changes to the election law itself. It's hard to predict what sort of changes would be made, but those changes would aim to weaken judicial and bureaucratic oversight over the elections, or rather use the state apparatus. Taking a step further, use the state apparatus, those judges and bureaucrats, in ways that would all but eliminate the potential opposition victory moving forward. So I think social media and election laws and arrangements would be, particularly susceptible to further government crackdowns if and when the People's Alliance wins the upcoming elections. But I know this is not a question you asked, but to sort of as a sort of flip side scenario, if I may, I think it's also important to think about what the opposition would and should do if and when they win the next elections, right? I mean, we talked about the desire, the joint desire on the opposition's part to go back to a parliamentary system of government, but that's, at least in its current form, a rather vague sort of promise commitment. It's very ideologically vague, and maybe rightly so, because the opposition forces are not ideologically well aligned. So it could be, it's perhaps natural that the proposal is sort of vague and nebulous at this stage. But to the extent possible, I think the opposition should come up with, a concrete roadmap with various timelines and concrete steps to be taken within those various timelines. So, going back to a parliamentary system of government, what are the details? What's the amendment package? What articles of the Constitution are you going to target? How? Re-acceding to the Istanbul Convention, maybe a moratorium on prosecutions involving alleged defamations against the president, or better yet, decriminalizing defaming the president altogether, or better yet, decriminalizing defamation altogether, and making it a matter of civil law and not criminal law. So the list would ideally have items like these, sort of ordered according to their level of urgency. I think that is what is currently lacking on the opposition side, and what they should be working on. Again, to the extent that it's feasible, and that doing so wouldn't sort of tickle the cleavages that already exist among opposition circles, given that they are an ideologically diverse group of parties.
Cem, katıldığınız için çok teşekkür ederim. Cem, thank you so much for joining us. It's been a real pleasure.
You're welcome. My pleasure. Thank you, Nick.